Good afternoon, everyone, and welcome to Law 3481, Emerging Legal Technology and Practice. This afternoon we have a panel discussion looking into the future with an esteemed group of guests who all have a variety of interesting backgrounds and diverse opinions to share with you today. And I'm most fortunate to be chairing the panel discussion. My name is Angus. I'm a lecturer at the University of Southern Queensland and a partner and trademarks attorney at Irish Bentley Lawyers. I'm also a co-founder and director of the Legal Forecast and involved in a number of civil society organisations. But I think what's probably going to be more relevant today is to hear from this wonderful group of people who will be sharing insights about the future based on reflections in the past and current practice as it's evolving in law. With us today, we've already heard a guest lecture on design thinking from Warwick Walsh. Warwick is the founder of Lawcadia and has more than 15 years of experience as a corporate lawyer in London, Sydney and Brisbane, advising companies on investments and acquisitions. For those of you who had the opportunity to see Warwick's presentation this morning, it was an informative and extremely interesting coverage of what design thinking is and the process of implementing solutions into legal practice and other industries. We also have Jess Caire of PEXA here with us today. Jess also has 15 years of experience, although in change management, marketing and property law, having built and sold multiple small businesses, conveying thousands of properties during that time, many of them being on PEXA. She has brought this valuable experience with her when she joined PEXA in March 2018. Jess has a keen eye for detail and a passion for emerging legal technologies and innovation, and sharing those ideas with you to make your practice more secure and efficient, giving you more time back so you can focus on the important things in your practice, such as your staff and clients. As a Queensland resident and executive manager stakeholder engagement, Jess maintains a strategic relationship with the Queensland Law Society and regional societies and embodies this spirit of partnership to deliver smooth rollout of PEXA in your state, and has a property law qualification to formalise her Bachelor of Business. Beside Jess, we have David Bowles of the Queensland Law Society. David wants everyone to share in a world where change is for the good. New is an opportunity and life is an adventure. He is a solicitor with the Queensland Law Society and the latest phase of a 25-year legal career. His current work focuses on design and delivery of information security programs for law firms, project management and ethics. His previous work includes work over the last 5 years as the Queensland Law Society's ethics counsellor, assisting nearly 4,000 practitioners to navigate the complex issues in modern practice. He has owned his own law firm and worked in commercial law and criminal law practice before that. His qualifications include law and public administration from UQ and a graduate diploma of legal practice from QUT. He also has a number of qualifications in cybersecurity, and David's background brings a wealth of knowledge about all the issues that are facing practice today. Beside David, we're fortunate to have Chantal McNaught, who has generously contributed time alongside many of these other people in this course already. Chantal is a qualified lawyer and LEAP's client success manager. Chantal's legal practice experience was in migration law, and when Chantal left legal practice, she continued to remain close with the profession, opting to work in the marketing department of a national law firm publishing legal content online. As a client success manager at LEAP, Chantal assists lawyers, practice managers and support staff with utilising their practice management solutions to its fullest potential. Chantal has a Master of Laws and a Graduate Diploma of Legal Practice from the Australian National University and completed her law degree with honours at Bond University. And beside me, we're fortunate to have Stephen Tyndall. Steve has led the IT function for Australian law firms and is a founder of the Client Sense and Client Retention and Business Development Solutions at NextLegal. Steve presents regularly for the Queensland Law Society and Law Institute of Victoria, and I understand our colleagues in Victoria will be fortunate to have Steve attending their practice management course in the coming weeks. He is also actively involved in legal technology and community and is a founding member of the Australian Legal Technology Association. As I said, I think the best place to take today is an open discussion with our panellists. If there are questions, feel free to prompt them. I have an audience here, so I thank the audience here. I also thank the audience online. This is an important discussion that's happening across the legal profession, not only in this country, but internationally. And the more expert opinion we have, the more informed conversation we have, and the clearer picture we can paint for current practice, the better we're able to navigate the future of practice. So, starting with context, and I've given a slight context to this, let's start with an introduction in terms of where each of you have come into legal practice. And we were just speaking about this before. David, you have an interesting story, so maybe we might start with you.
Oh, I guess so. I had a somewhat meteoric rise. I was employed in a small firm as a graduate solicitor. I was one of the two there to do civil law. The morning I arrived, my supervisor had a towering row with my partner, with the firm principal. And so my induction was, there's your new office, don't screw it up. They had the legal equivalent of being raised by wolves, so self-taught and had absolutely sort of no guidance or mentorship in civil law in that firm, which is, I found it useful, but I've certainly made it one of my jobs at the Law Society to make sure that people don't have to go through that, because it took many years to get back to the point where I could have been at if I'd had more direct supervision and training.
I suspect that might be a common theme across this panel in terms of the entry into legal practice. And how about yourself, Warwick?
So I started my legal career in Sydney at Blake Dawson, now Ashes. Worked in London for a few years at top-tier, mid-tier firms over there, and then back in Brisbane. Then left my legal career behind in 2015 to set up Lawcadia.
Excellent. That's probably a happier and smoother start maybe than some anticipate. And Jess, how about yourself?
Yeah, mine's not as brutal as yours, David, but I'm actually a registered conveyancer from South Australia originally. So I completed my property law component down in South Australia about 15, 16 years ago. And I was always pretty ambitious and decided that I really wanted to own my own business, and learnt pretty quickly that owning a business and being a good conveyancer weren't two things that naturally went together. So I had to learn by a bit of baptism of fire. And I think the last sort of 10 years of that self-employed journey taught me a lot about why I liked doing what I do, but also how important it is to be engaged within your industry. And that was probably a perfect transition across into my role at PEXA, because things had changed so much during that time that I was a conveyancer, and I think it will change rapidly even in the next sort of 5 years. So, yeah, it wasn't a tough introduction, but it was certainly one that I had to learn along the way. So.
It's excellent to have that thread of passion that flows through, and the foresight to see that passion develops into something and continue to develop. And Chantel, how about you?
My introduction to legal practice was actually before university. I was 17 and I was lucky enough to have an older sister who had her own law firm down in Melbourne. So I spent 3 weeks with her, and fortunately it was only 3 weeks. And but I learnt then, I tried it, I was on the precipice between, do I go down the sciences or do I do law? Because everybody said, oh, you're very argumentative, you should do law. And I thought, yeah, this practice seems pretty cool. I was able to argue with the register about something and helped with some filing. And then when I went to university, I discovered that the law itself is vastly different to the actual practice. And so when I went into my career, I saw that I had this internal conflict between the love of the actual practice, the business of law, as well as the actual academic side of applying legal principle to relevant facts. And in 2016, that's when I took a step back and decided to assist the greater legal community with their legal practice itself from the business side of things.
I think that's a really interesting and important point that can be taken out of that as well, is that the hybridisation or the relevance of the academic pursuit of law as well as the professional side in whatever form that takes. And Steve, you've had an interesting series of steps walking with the legal profession. How about you?
Yeah, absolutely. So I guess my background differs quite significantly to those here. My background, my profession is in technology, so in information technology. And when I remember the first time I was interviewed for a role at a law firm, and the question was asked, how are you going to go working with 50 bosses, 50 partners? And I don't think I quite understood really what that meant at the time. I certainly do now. And I guess where I've seen legal, I guess legal services and technology come together is really interesting. So there's certainly been at a time where I believe legal technology was almost an oxymoron. Now it's at the point where it's something of substance. So what I've found really fascinating is just how I guess how these two intertwine. And so my background being in technology rather than law, I'm finding that we're blending more and more by the day and by the year.
I think that's definitely, and it's a very rapid progression that we're moving forwards through with the profession and across society generally in terms of what we expect out of legal service and what that landscape looks like. From my perspective, I probably would ascribe to the baptism by fire approach that some of you have spoken about. My first introduction into legal practice was as a paralegal in a personal injury firm in Toowoomba, at the same time that I was studying law, and I learnt very quickly that paginating is a process, and paginating is a part of legal work, or at least I was told it was. And with that starting point, I was given a very mundane task of please stamp a number on these 15,000 pages and ensure that each page has a number on it before you put that into a brief to deliver to a barrister. And I very clearly remember being at hour 6 of what would turn out to be a 10-hour day, constantly hearing click, 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 click. I would definitely agree with the passion point, that passion is something that is my thread as well, and I don't think that I could have taken that without a passion. But it does segue nicely into the first question I have for the panel. In my view, a paginator was driven by a desire to make handwriting numbers on pages more efficient. At the time, I certainly didn't think that was the case. But now, with the advantage of reflection and hindsight, I can see that that was probably quite a valuable and seminal point. For each of you, and start as you will, what do you think the core drivers for change have been in the legal practice, or in legal practice, from your first entrance to where we are today?
So personally, I think the big change that's really hit the industry over the last 3 years is this concept of legal operations. I was actually just in Sydney yesterday for the CLOC conference in Sydney, the Corporate Legal Operations Consortium, and that's something that's grown massively. It's over 200 people in Sydney. The conference in Las Vegas every year gets 2,000 people. It's driving significant change within corporate legal teams around how they work, what processes they use, where they brief work, and what systems they use. And it's actually creating new roles and role types, which I think is very exciting for the industry. I think that's having a flow-on effect to law firms as well. And I think in an industry where legal and technology, as Steve said, hadn't traditionally been enmeshed, I think it's creating a really exciting growth area for the industry at the moment.
And Steve, do you think that merger of law and technology and legal service operations has been a big driver of change, or are there other drivers of change over the last couple of years leading into the point that we're at today?
Yeah, look, I think from my point of view, I've always seen that how the two, legal and technology, are put together almost is driven, as I see it, from obviously the client's expectations. And I tend to believe that we're in an information period where information is easily accessed, and that means that client buying behaviours have changed, and their understanding or appreciation of what specialists they need and how they should go about doing things has changed. So whilst I come from a technology background, I've always believed that technology itself shouldn't be the driver as such, but actually the enabler that follows in as to what it's actually trying to solve. So from that point of view, I'm seeing, I guess there's a bit of a shift. Some firms will look to take on technology as if that would be a point of difference, but actually I think the greater point of difference is how you service your clients, how you provide your services, and then the technology follows, in after that, really, if it's done properly.
I think that's great to have the outside look into the legal profession, because that might be a slightly a clearer picture for you maybe than some of us who are caught in the process of practice. But that driver with technology, Jess, obviously with PEXA has driven quite a big technology change in legal practice.
Yeah, arguably the biggest disruption in property law since its inception. So I think, to your point, I think absolutely consumers are expecting things to be delivered in a more digital component, and they're more switched on now than ever before. So they buy things digitally, and they expect that their services professionally would be delivered that way as well. So I think that certainly has been a driver for the change. But I think too that legal industries have to become a lot smarter about how they're delivering things in order to create the efficiencies. We don't live in an economy anymore where you're able to have multiple headcount stamping pages. We're expected to deliver much more meaningful work, and I think that's certainly a drive, and I think that is related back to the consumer component.
And there are a variety of aspects that attach to digital disruption of legal services. Chantel, can you see other drivers for change that might be approaching or facing the legal practice from your point of entry in migration law to where you are now with legal?
Yeah, so I did practice in migration before I left practice, but what I see as a big driver of change, and I've heard it across the panel as well, is that it is the stakeholders. So not just the clients, but also every single stakeholder that a legal practice interacts with that drive that change, that drive that necessity to do something about the productivity inefficiencies, or it might be service delivery with the legal operations, that sort of thing. So, for example, I want to draw on PEXA because a year ago when I was travelling around Queensland speaking with firms that electronic settlement was just not an option. They saw that as actually inefficient. What happens if a party drops out? Then we're going to have to do everything by paper anyway. We just prefer to do it by paper. Now it's the reverse. It's we have to do everything electronic and we'd rather not do it by paper. And when I dig a little bit deeper, it's actually the banks that are driving that. They're saying, you know what, we prefer electronic settlement, we're not going to prepare a paper transaction. And then that drives the law firms to actually do something about it in their practice.
Yes. I think that's entirely right for the majority of legal practitioners, which of course still work in the smaller firms. When you say what's driving change in small firms, I think it's remarkable how little there has been in the last 20 years. You walk into a small law firm in Browns Plains today, it looks very much like it did in 1994. And I think, you know, this is probably the last 5 years where you could say that. But the change has all been the external stakeholders, the registries, the banks and the big organisations. But increasingly that's going to come down to the clients now, because the big end of town, you know, you've had that client drive where, you know, clients look at you in disbelief and just say, you know, if I ran my business the way that you ran your business, I would have gone out and I couldn't afford to pay your bills. So I expect that sort of level of project management and cooperation that, you know, I just have to supply to my internal stakeholders. Retail clients, of course, don't have that driver yet, but they will. I mean, certainly when a bank's offering wills for $50 or anybody else is able to come online with a decent digital offering, then that's going to be a very rapid change. And any person running a small law firm that's not sort of looking at that and thinking about it is really in for a nasty shock in the next couple of years, I think.
I think that's a really insightful series of points, and the term drivers of change I take from Richard Susskind's work, and particularly the work Tomorrow's Lawyers, where he describes 3 drivers of change. The more for less challenge, which goes to the cost point. It's difficult to compete with a bank that's offering a $50 product at the scale that they're able to offer it. The liberalisation of legal services, such as banks offering services, or what's happening on the big end of town in terms of multiple disciplinary practices and new ways of practicing law. And technology, which I think everyone has touched on, digital disruption being a particularly big driver for change. I think it's an interesting point that you make there, David, that there's a lot of talk about change that's occurring, but that may not be a completely ubiquitous process at this stage, and we're still in the process of that developing change, which is why I always think it's optimal to start with a context, and that context is the past, because we can learn a lot from what's happened in the past, both from the sense of failures and from successes where technologies have been adopted well, and that served a more efficient means to operating. When we talk about liberalisation of legal services and the widening up the scope of what the legal profession is, Richard Susskind, in my mind, puts a lot of positive connotations around that process, but there's potentially risks that sit around liberalising legal practice. David, maybe starting with you from the ethics perspective of that, or a broader perspective if you'd like. Do you see liberalising legal services as an opportunity or a threat?
I see it as a reality. I mean, there's no positive or negative about it necessarily. Queensland had a remarkably quick transition to that. Like, if the Americans have tied themselves up for years and we just essentially said, look, not a problem, the assumption was that people would just take their little legal practices, they'd incorporate them and then continue to run them exactly the way that they always had. And to some extent, I think that assumption was correct, but that's, again, going to change fairly quickly. Somewhat remarkably, it is far easier to set up a law firm in Queensland than a brothel. Far more examination of your character for providing other services. Fortunately, the bikies never worked out that you could own a law firm, which would have sort of put the cat among the pigeons a little bit. But certainly, I don't think that the reality that we've seen in the last 5 years is going to be the reality we'll see in the next 5 years, as increasingly, companies approach regulators and say, I'd like to do this, and then regulators say to them, well, no, you can't, because that's provision of legal services. And then they go away and they think for about 42 seconds and they say, oh, I'll set up an ILP and we'll get in a grad to run it. and then problem solved. And so there are a lot of people that have reached that conclusion, and they're setting up businesses and they're running them now. Real estate agents at the start, but I think that's a matter of time before there's probably 20 or 30 people on that list.
I think, David, you make a good point about how there are other industries out there that are far more regulated from that external sense. Suskin comes from the UK, so he might be drawing upon his experience. UK firms are highly regulated. They're audited in their entire practice externally, while here we have trust account audits, and that's pretty much it. Everything else is self-examination and self-determination. So I think that's where the confusion is that there isn't any guidance from a regulatory body.
The Commission here, of course, has legislative power to have a much more intensive oversight of incorporated legal practices. They started out doing that, but in recent times they've backed away from that. But that stick is always there. So anyone that thinks that there is no regulatory oversight of ILPs in Queensland, you're in for a nasty surprise.
Was it what sorry about that, the confusion.
If you get a regulator in the seat that decides that really closely looking at those internal operations is worth the resources. So.
And I suspect that's an aspect of this entire conversation, and it's being touched on, I think, very appropriately. This is something that's happened very rapidly. So where we have a regulator, I mean, the reference to the UK, I think, is the 2003 Legal Services Act and alternate business structures that exist there. That was a big disruptor because that was a change to the way that law in its entirety would be practiced, and there was a lot of fear around that. And you're right, in Queensland, as I understand, when we introduced incorporated legal practice and multiple disciplinary practices, that was more embraced than feared as that makes sense, we should do that. Maybe from some of the other panellists, and maybe Steve, from your perspective on the technology side of this, I would imagine you'd see liberalisation as something that's beneficial for the profession, or do you adopt a more neutral approach or something else?
Yeah, look, I think, like David, I guess I see it as inevitable in that there will be a liberalisation of those services, and technology where it fits in obviously enables, I guess, a range of different services. So what I would see or say around that is that I see a lot of firms that are using technology to offer services that are very different to what was offered in the past, and even moving into more proactive legal services rather than reactive. So there's a few things there that don't fit into that traditional legal service delivery model, yet they're beneficial services. And I guess from a technology point of view, it is great to see those types of services enabled, but obviously there's consideration around legal advice and all sorts of other considerations that need to come into that as well. So I've seen firms move, like the other panellists. I think I've seen a lot of change in that space in the last 5 years, and that's probably where most of the, call it innovation, or most of the change is really coming from, around the less traditional sort of offerings.
Yeah, I think it's, again, we're all touching on a very similar point here, that there is change happening and there's technology that drives that, and the stakeholders are quite important in this as well. And Warwick, we've discussed this point about stakeholders and the importance of focusing not just on the law practices, but also the clients and the parties that are involved in the process of the provision of legal services, including in-house counsel. Do you have a view on the liberalisation of legal practice?
I guess I come a little bit more from a B2B perspective as opposed to B2C. But I think the liberalisation, which is definitely happening in Australia and is massive in the UK, is that contract lawyering service. So it's not necessarily liberalisation in terms of providing it through a legal practice, but lawyers on demand, contract lawyer services. They're providing legal services to a client, albeit it's not a law firm, and the people who are being placed in there is a different way for clients to resource matters. The big trend that's really started in the US is that unbundling of legal services. So instead of just going to a law firm and trusting that they'll do a good job and resources the way they want, they'll have a legal process outsourcer, they'll have electronic discovery, they'll have contract lawyers, then they'll have the law firm managing it. And so what that creates is, I guess, different skill sets and advantages, probably similar to the way that people are doing it, within the consumer market.
I do think that changing the underlying ownership structure will have a really fundamental effect moving forward, because it changes the DNA of the organisation.
Yeah.
Partners, when you're a partner in a firm, even in a really big firm, you have a certain economic imperative that drives you to short-term thinking. You don't want to store value in the organisation. It's really hard to shake up the organisation to be thinking in terms of 10, 20 years down the track, because nobody sort of sees themselves really as part of an entity that goes on. But that will change, with the corporatisation. First of all, you get the professional management that you're talking about, and the legal ops, and this absolutely explosion of people that you wouldn't have even seen 5 years ago. But you've also got, as the old partners retire, you would get people with a very different management ethos. They're there to run a business, and that they're not really the owners, and they look at it in a very different way. Coming back to Steve's position, I think the difficulty is when you started out with having 50 bosses, increasingly now you'll have a CEO, and that's a very different beast. So.
Absolutely.
I think that's a really interesting, insightful point in terms of, and myself as a partner, there is definitely a business of law, and then there is a practice of law that runs alongside that. And, as you become more and more towards the business side of law, you kind of have to drop back a little bit the practical side and come off the tools, which for me is one of the most difficult things to do, because that's why I went into law. I think as the business modes change, and the point you made there, David, is profound. The succession planning for knowledge and the teaching through mentorship into the future, which is what essentially has happened for a very long time in the profession. There would be a hierarchy, and that hierarchy would have mentorship within it.
Yep.
The transition to a business maybe commodifies law in a way that affects the practice more fundamentally from the structural sense, not just its operational sense. Technology may be a way of alleviating that. And Jess, I'd be interested in your thoughts on this in terms of what role PEXA has in this process in liberalising legal practice and maybe opening up opportunity.
Yeah, so I think first and foremost, I think the consumer has to be at the forefront of everything that happens, the changing environment. Obviously, like I said before, consumers expect a lot more now than they ever have. I think there is a risk, and obviously we've heard this time and time again in PEXA, is that I won't adopt, I'm going to retire before that happens. And there's a great concern that we're dealing with change behaviour and change psychology every day when we're in and out of law firms, and I've been into lots in Queensland over the last year and a half, and the knowledge that person potentially takes is, PEXA's not there to replace that knowledge. PEXA's there to automate more of the sort of mundane administrative components of conveyancing, with the view that you're able to free up time to do more meaningful work. We all know that despite how great technology is, humans need other humans. We need relationships. So I even think in a world where banks might offer wills, humans will still want to engage with another human, because that's fundamentally one of our needs. So I think it's really important when we're looking at technology, and this is something, we approach change with empathy, because people need to be understood that they're not going to become irrelevant, and I think that's a bit of a fear component that we face every day from people, refusing to adopt potentially, but also how they can then apply their knowledge down the line, because the young 22-year-old might be fantastic on the tools, but might not have the legal nous to be able to answer the tricky stuff, which is why they became a lawyer in the first place. So it's sort of that really delicate human interaction that's required, and I think that really comes down to how you engage with the psychology of change. Because I think really that's what the fear of technology is for people. So, and then how do you then engage that to build a really meaningful relationship base with your clients?
I think that's another very, very important point in terms of the way that change is both understood and then managed. And I couldn't agree more with everything you just said. I think it's quite interesting from my perspective. I sort of came from not being a digital native and then into a very digital world through practice. And the example I gave about the paginator, that was a horrible, horrible process. I have very, very, very clear memories of hours and hours and hours of doing that. And I didn't understand why at the time. Now reflecting back on it, there were a lot of skills that were being adopted in terms of attention to detail and the process and the ability to communicate mistakes to people, where I've missed page 3,742 and I'm now at 10,780. What do I do?
Can I just share with you the joy I first found in seeing a paginator? It was just, oh wow, I love that thing. If you're grown up writing them on by hand. So this is, this is to some extent, we've been here before.
Yeah, exactly.
And it's only a further iteration, but yes, sorry, I cut you off.
No, that's an entirely appropriate point to take this, David, because I couldn't agree more. It's that communicating the change that the paginator to me made sense the moment I ran out of ink and I had to start writing with pen, because that took a lot
Yes,
longer and it
yeah.
was a lot harder than simply stamping
Yeah.
something. And it's understanding that change and embracing the change as an opportunity rather than as something that's
Yeah.
to be feared.
Perhaps with addressing the skills shortage that you speak of, with those that are exiting the legal profession, that are retiring or tapering off their work, that adopting technology to be able to supervise more effectively the junior personnel. So I guess one of the examples, I remember a firm was digitising 30 years of their archiving that couldn't be destroyed. And they had a recent law graduate doing that because she had to go through and confirm all of those things. And I remember when I was archiving, I didn't get matters until I archived. And then that entire life cycle of a matter and a client didn't fully click until I was doing this mundane archiving and realising, oh, that's what it is.
Yeah, absolutely. I think there's a component of when we talk about change, and especially from a technology point of view, people have an idea that you flick the switch tomorrow and everything's different, and it's not. It's very gradual. We've talked about this, it's a gradual change, and also you can adopt as quickly as you like, but also probably at your own pace. I think that's where we're really in a great spot in Queensland now from our point of view, is that people who are adopting, they're doing so at their own pace, and then being able to go back and actually concentrate on what they're doing, almost relearning things again, because sometimes you just do what you've always done because it's comfortable. And I think you're right, that way you can go back and explain to the person why we're doing it this way. I do certainly think that there's the element for people to really take their businesses to the next level by adopting at their own pace and being able to use that knowledge to filter back down to their youngsters. And I imagine lots of young people would want to look for firms where there's a capacity for them to grow and have that mentorship. I'm not sure if that's available to everybody. I'd like to think that it is. But we certainly don't ever want anyone leaving the industry. And some of our adopters are people who blatantly said we'll never ever do it, and who are now our number one transactors, and they're in their 60s and they're having their best life because technology has changed the way that they run their business.
And it's not just knowing, it's also comprehending.
Yeah.
And I think that is something that people have, or the profession has a responsibility for the emerging lawyers, the emerging leaders of tomorrow, is helping them comprehend the technological change, because we're seeing a lot of change now for the next 5 years. It's probably going to get, it's going to hockey stick.
Yeah, absolutely.
So we have to give them the skills to deal with the next iteration of change.
I touched on before at my entry into conveyancing, I said that being a good conveyancer is not equal to being a good business owner, and I think there's more pressure on lawyers now to have the business acumen than ever before, and so there's an element of having to have that nous and being savvy about where is your business headed, and I don't think it's ever been like that previously, where you should be a really good lawyer and not worry about what the future was unfolding, but because it's changing so rapidly, there's definitely that requirement.
I think the global financial crisis actually had a great opportunity for the profession, because by making everyone have to focus on that business element and focus on what the clients are actually able to do and willing to do, as opposed to the golden days of the past, I think that actually presents more opportunities in the future, and may in itself have been a driver for change. Before I pose another question, I do note we have an audience here with us, and if anyone would like to interject or throw questions into this, feel free to raise a hand or jump in. It's an open conversation. But I had a question that ties sort of on the back of technology, and the next 5 years is a hockey stick where we really ramp this up. And maybe David would be the best person to start this. I would describe technology as a tool, and simply a tool. It's not neutral. It doesn't have to do anything. Not good until it's observed in a good way, and not bad until it's applied in a bad way. It is simply a tool that's used in practice. We're rapidly adopting technology solutions not just in the legal profession, but across society generally, at a phenomenal rate. There are, in my view, risks and benefits that attach to technology, and particularly in the application to legal practice. Do you have a view on some risks and some opportunities or benefits that exist with respect to technology?
I mean, the obvious benefit, of course, is the access to justice thing, because, when we sit here and say, well, the good old days, they were the good old days for people who could afford to pay for bespoke, hand-built legal solutions, and that the reality is that is the vast minority of the population. So when we say we do the best justice in the world, that is not true for people who cannot afford a solicitor. Those of us who practice have forever seen these poor buggers wandering around the system trying to interpret it themselves. So that's going to be the obvious issue, to increasingly make life easier for people that have simple, repeatable problems and need assistance to do that. That'll probably sort out, I'd say, a good 80% of most ordinary people's legal needs. It won't sort out the last 20%, which have the more complex problems, and there will be some downside of that because, of course, as we've seen just with the non-technical evolution of practice, when you pull the profitable day-to-day work out of a small law firm, you break the ability to then look after the more complex issues or the one-offs that people get. So I think you'll increasingly get sort of this two-tier system where the routine work is picked up and it's done sort of increasingly in an automated way. Getting a part of that business is going to be really hard, and that will make a really drive a challenge for those that are trying to look after the last 20%. So that's probably the first main one. Secondly, from an ethical perspective, generally what triggers an ethical response in a solicitor is knowing you've got to look the client in the eye and do something either to them or that will affect them, and that is the real driver. For people who are dealing increasingly with automated systems and with people that they never meet, they never see, we really need to get a more high-level ethical analysis to say, well, look, what is fair in dealing with somebody whose interests I am now affecting, but I'll never meet them, they'll never meet me, and they don't have any insight into what I'm doing or the algorithms I'm using to do it. So those are the two primary things I'd see.
That's a really, really important point in terms of and it goes back to what Jess and all of you have been discussing in terms of the human element, the client focus, where you interpose points between the client and the person providing advices. It probably would become more difficult, I suppose, to keep that moral compass where you have to look someone in the eyes and say, this is what I've done, as opposed to it being detached with technology. And I don't think that's necessarily something that's alone in legal practice. That might be something that's generally existing in society that could be a disruptor of society.
Yes, Duke University did some interesting studies on the ease by which people purges themselves by a remote link as opposed to standing there in court, and the rate was an appreciable double percentage points higher. So there is that real disconnection, human to human thing, and we need to get to grips with that, I think.
Yeah, that's a really, really important and very interesting point. And Steve, from the technology side of this, the risks and benefits that you see, I suppose, from the outside that exist within legal practice and the application of technology.
Yeah, look, I think there obviously when new things are introduced, there's always a risk. If I can say it, a lawyer will find a risk where there is a risk, of course. So more so, I think that's one of the things that really makes it difficult for law firms to adopt new technology, because the truth and the fact is there always will be some risk in adopting anything new, really, whether that's a technology or something other. There are massive benefits in doing so. I think there's a few different ways that firms can really start to ease into that. I don't think that it's really a leap of faith they need to take as such. So whether it's any form of machine learning or any type of thing like that, it'd be, to me, about really confirming or applying that against what we know and what you understand and the results you would expect. So I think if you were cavalier with technology, of course, there'd be risks all through that. But also, I think a fair risk is not adopting certain technologies as a business. So forget being a lawyer here, but if I all of a sudden can't charge the hourly rate that I did for some commoditised work, that's a threat to your business. So I'd always like to think that while there is a risk in adopting technology, I actually see there's a risk in not as well, which needs to be factored in.
And on that, we're seeing the courts adopt technology. They might need to investigate those that perjure themselves by link, but as far as lodging forms online, you've got the Commonwealth court portals, that sort of thing. So that's where a firm must adopt technology, or at least adopt the comprehension of using the technology in order to service the duty to the client and to justice.
Yeah, well, I think that the point that Angus regularly makes, that we have a de facto duty of technical competence, and I don't think anyone's arguing about that. I mean, despite the fact that it's not expressly stated anywhere in our conduct rules, you can't expect a client to be paying a graduate to sit there and paginate 10,000 pages. And
exactly.
I think looking back on your experience, I would bet that if they'd really had a good look at their photocopier, they could have got that automated and saved you the day.
I'm pretty sure that there were any number of ways. I think that's a really good point in terms of leaning into technology,
Yes.
and that this is not just something that sits on one side of technology. There's the obligation almost to adopt technology where you are doing things more efficiently, like the PEXA platform, or like online filing of court documents, or like video link evidence where you don't have to fly, or at least directions hearings, maybe avoiding the perjury issue. And maybe Roman Polanski has a position in Australia in terms of how well that will go for the future. But it is an interesting space, and it is quite interesting to have to now, as practitioners, understand the environment a lot more clearly than what was done in the past. And the access to justice point, the golden days certainly, as you said, were golden for some, but for others, certainly not so much. And that access to justice point is really an important underlying and underpinning point that exists within the adoption of technology. When we're adopting technology, Warwick, I understand the Lawcadia platform has done a number of things in terms of assisting with efficiency gains and ensuring that billing milestones are being met appropriately and that the system is actually operating effectively.
Yeah.
Do you have thoughts on this? Can you explore the risks and benefits of technologies from your perspective, or innovations?
Yeah, I think it does start with the client. I think but what you really need is you need a pain point that you're trying to solve. And if there's a pain point, it's potentially cost, but actually time and energy are actually bigger drivers. And where you've got a pain point that is causing people within a law firm, if it's partners, within corporate legal teams, it's general counsels, 2ICs. If there's that pain point that's significant enough that's going to change behaviour, then that's probably where there's a solution. It may be technological, it may not be, but that's where the opportunity I think arises. And we've been really fortunate. We felt that we started off with a clear pain point for corporate legal teams that's allowed us to build our business. And as you work with clients, you actually find out more and more pain points and different ways to work with your client, and you iterate the technology like that.
Could I ask a question? What was the difference you saw between the mindset of external legal counsel and an internal legal team? Was it fundamentally different, or were they just lawyers in a different pot plant?
So I was actually I was a corporate lawyer. I'd never actually been in-house. And when I took my sort of legal hat off and went to some contacts and said, I'm going to start this business, and it's going to help corporate legal teams put structure around the way that you engage and manage scope changes and budgets. The frustration was just incredible. I had CFOs of ASX listed companies swear when they were describing the frustration that they had. And that's when I realised that pain point was significant enough that even if it's a new technology solution, people would be willing to explore that, to take that away. And I think that's possibly evident of lawyers not fully understanding the clients. And I think sort of coming back to change, it's always client driven, and where you've got that pain point of frustration, then people will find ways to solve that problem. So I think law firms now looking to solve problems for clients, I think is great. I think that's changed 3.5 years ago. I don't think that mindset was there.
Well, one of the big problems with external law firms, of course, was the billable hour, because pain is transferable under that, under those circumstances, you bill Angus's time to the client. There was no real need to go and find a solution. In fact, there was a positive driver not to, because Angus was Angus plus whatever they were paying you plus a markup.
A quite significant markup.
Quite significant markup. And of course,
that was the case.
For the partner to work out, hey, there's a better technical solution, and to go and drive people to do that, they wouldn't have been paid for that. And so what you're asking law firms to do, just in that really simple example, is to go and find a better solution on there and pay for it themselves, work it out themselves, have a partner take busy time out to go and find that solution, and then not sell the same number of billable hours to the client. So there was a real strong disincentive to do that, and I think until
I completely agree with that.
And until now, where the clients are just saying, "No, that's it, no more," And now we're forced to go looking for alternatives.
It's such a competitive playing field now, isn't it? That if you don't adopt, like to your point, if you don't adopt technology, you are at a risk of no longer being around. And if you're not going to, the law firm down the road is categorically going to, and they're going to do it bigger and better. So I think there is that pressure to look at the bottom line and start having that business acumen run through what you're doing, and again, and go back to that consumer element to say, what does the client need? Because if they can't get it from me, they will go down to Fred down the road. So I think that's probably been quite a behavioural change required from many lawyers to do that. So I think categorically there is a huge risk of us not adopting, people not adopting. We've seen it. You talk about firms before going in and they still like they did in 1994. They're, how are they going to keep up as the landscape changes so rapidly?
Just wanted to add, an additional risk is adopting technology when comprehension is not ready yet. So I've seen that quite a lot where there's generally place practitioners in two categories. Either you're a clicker or you only do what you're shown to do. And those that click around, they tend to be, get into positions like practice manager or a partner, and they want to get the new shiny toy. But everyone else they only see what they're shown, and so they don't explore outside, or they don't comprehend what the technology can do. So when they're faced with additional problems to solve, they don't realise they already have the tools. So then they expend more money and more time expense in trying to solve a problem they already have the solution for.
I think that's why change behaviour is so important, and it has to come from the top down. If the reason that you're implementing change and process changes and drivers within your business is not translated from the top to the bottom, you will not have adoption. You'll end up getting a blocker somewhere, and there'll be someone who doesn't want to fully accept the full package of the the operating system or what the capabilities are.
It's the find your why.
Yeah, absolutely.
Yes, yeah.
And Simon Sinek has an excellent presentation on defining the why. And I think that concept that business is actually driving a lot of the change in legal practice, and that's potentially because it's more client-centric and competition-aware than we've been in the past, I think is a really important takeaway point to be drawing from this. Part of the history of this evolution, and I'd go back 5 years, but I'd say it's probably still as relevant now as it was 5 years ago, and I could probably cast this back to every point in time that something's changed within legal practice, with technology driving the change, and that is the fear that lawyers will be replaced by technology. In my view, it's not replacement, it's supplement or assisted with technology. I don't think the actual core of lawyering can be replaced. But it is a discourse that sits around this space. What's the panel's thoughts on whether technology replaces lawyers, supplements lawyers, or does something else?
I think we're going to be subject to this. We've been chucked into a nuclear reactor and bitten by the radioactive spider and all of the other sort of, nerd references you can come up with. We're going to change, and it's going to be dramatic. I think if you look at pilots now, the skill set is not somebody that can fly through the storm and hold the stick. They run a complex organisation essentially in the sky. They're not really necessarily flying anymore. They are troubleshooters. They are the ones that say, hey, there's a mountain there and the sensors don't seem to have picked up on it. They're the hostage negotiator. They do a wide range of things. And I think the same analogies will apply to solicitors in particular. Counsel, I'm not sure what's going to happen to them, but solicitors, I think we're capable of making that adjustment. Some of us will pick up and go off and learn coding, and that will be a necessary thing, but I don't think that's necessarily what we all have to do. But we will, I think, the lawyer of today will not be the same as the lawyer in 10 years' time, but we'll still call ourselves that. We'll still have our same base training, and we'll still have that, I think, the same basic outlook on the world.
I think it's the core skills that are a really key aspect of lawyering. The critical reasoning and critical analysis and problem-solving aspects are really the true fundamental basis of law. And I certainly like that pilot analogy. That's one that I might take, Dave. That's a very good analogy. From a slightly different perspective than Warwick, you have a lot of time and experience with in-house and dealing with in-house. To my knowledge, that's something that's growing rather than shrinking, and technology might be assisting that.
Yeah, I think I don't think lawyers will be replaced. I think maybe if you look 20, 30 years ago, the role of in-house has changed a lot, and I think there are different career courses now. Being a lawyer, growing up, working your way through a law firm, being an in-house counsel is a separate career path now. I think you'll actually have other careers that come out of it. So legal project managers are now coming through. People who understand how to use the technology. There's some amazing e-discovery technology out there that's leveraging AI and capturing data and pulling information. And I think what it actually creates is a broader profession. I actually still think you'll have people who are lawyers exactly the way they are in 10 years. You'll have different people that support that in different ways. So, project managers that run projects. You'll have people who know how to analyse the data and use the tools. Because I think there'll be too broad a skill set for everyone to be completely across. And again, I actually think that's exciting. There'll be certain things that are replaced and automated. But I think there's other opportunities, and regulation, in my view, is only increasing. The need for legal services is only increasing.
Yeah, I think it's great to have that positive note. And from your perspective, Jess, because I think PEXA is probably one of the biggest, if not the biggest, disruptors in terms of lawyers or conveyancers arguably being replaced with technology.
Well, I'm a forever optimist, so I like to call us an enhancer. I like to think of, like I said before, technology giving you more time to be able to do the things that are more important. The stuff that makes you a lawyer isn't your stapling, photocopying of contracts and booking settlements on the phone to the bank. That's not why you got into property law. You got into property law so you can work with people to help their dreams come true and do property development. So it's really about taking away that automation component and allowing you more time, I said it before, to create those meaningful relationships so your clients don't go to the guy down the road. And you can only do that. There's only X amount of hours in the week, and we all know that lawyers are incredibly overworked. So what can we do to shave time off so you can actually have time to do that business networking, growing, learning about the technology that you're implementing, understanding the business acumen of your firm. So that's how I like to see, and that's certainly how I embrace PEXA within my firm and automation. There's only lots of QLS members are obviously small to micro business owners. How do they get more time back without having to hire new people and then their bottom line getting impacted? You can only do that by automation and embracing technology.
I think that's a really, really good point, and cognizant of the time on this panel discussion, and potentially we have questions here in the audience, so I'll hold off and throw this to the audience for some quick questions.
I come across a lot of businesses starting up in the practice of law and trying to discover what technology is going to do to help them, and Google is just not going to give them the information. So where do they start? What do they look at?
Call
Who
Steve.
do they go to get
Call
That's-
Steve.
Steve's only one person.
I know. He's
What's the
a
tips
talented
that you
fellow. It's a job for the law societies. It's one we struggle with because no individual business owner starting out can really get their head around this stuff. Steve has a really valuable niche in working people through that. Unfortunately, the reality is, without being too blunt about it, somebody that hasn't made $1 yet is going to struggle to justify your services in a full sort of consultancy. So, but go to Steve's website, practical sense, look at that, listen up at the practice management course, and then ring people who are using them and work out how to deploy technology. And I think that just means really being really brutal with the salespeople. So.
Yeah. And I think even ask people, ask your providers. So one of the things I saw commonly was that a firm or a sole practitioner wouldn't be engaging with their provider, and they'd tend to Google rather than actually asking the question. You'd be surprised, I think, what the providers will do and how far they'll go out of their way if you do that. Getting the initial start is tricky, but once you've got that provider and you're working with them, I would suggest absolutely engaging with them and asking questions. Yeah.
Can I also ask, please, about other legal? I think you mentioned across the board what technologies will affect, how technologies will affect the legal practice. Can you be more specific to a specific area? Do you think like a specific area of law, like intellectual property, or any other area, will be more? It will have more implication in terms of technology and how it will change the legal practice. And I'm interested in intellectual property, and I would like to know your thoughts about the future of technologies and how it will affect intellectual property specifically. Thank you.
as an IP practitioner, I might jump on that really quickly. I don't think it's something that's isolated to a single practice area or a single practice style. I think this is something that's happening across the board. And I think, as we've discussed, I think the business is really driving this. In intellectual property, there are easy examples. I mean, IP Australia's trademark search, for example, is a perfect adoption of technology that has assisted efficiencies in trademark applications quite significantly. And you'd see, for example, Section 222, capital A of the Trademarks Act specifically refers to computerised decision making, and that is the manifestation of adopted technology by government, which is probably even slower moving than industry. And then there's a number of searching tools and infringement monitoring tools that exist now across trademarks, patents, even plant breeder rights, which are rapid adoptions. And then built on the back of that, there's all the client-facing, client interaction and costing processes that are being brought into practice. There are very few examples in intellectual property law, just off the top of the head. But I don't think this is alone in intellectual property. In real property, we have PEXA that's a significant disruptor and enhancer of legal practice. And then what each of the panellists have discussed, I think, are applicable in each area of law that can be touched. And wherever humans are involved in system design and are willing to make the change and inform a culture of change about technology and the application of technology, I don't think there's a limit. Well, if the sky is a limit, it's a pretty high ceiling that we'll have to go to. Jess touched on the mental health aspects of technology and the mental health advantages of technology. Unfortunately, we're going to run out of time, so maybe we can park that for a further panel discussion because that's a big topic in this area as well. But where I wanted to leave today was, as there are a number of people online watching this, students and people who are engaged in this emerging legal practice and emerging ecosystem we're all living in. Maybe starting with Warwick, do you have a message that you could give to the future in terms of your view on emerging legal practice and the future of law?
That's a good question. I think it's an exciting time. I think there's a time of change, and I think you have to be really open to looking at and thinking about how you're going to work and where you fit into the ecosystem now and how you think that's going to change and what's your niche going to be.
That's a very good point. And Jess?
Yeah, so I would encourage any young lawyer to look at the history of the legal component that they're currently studying or wanting to sort of specialise in, understand where you've come from, where your predecessors have come from, and then be very clear that, you know, you might need to have more than one idea about what it is that you want to do, be it business, be it you know, technology, making sure that you're across and open to new ideas, because I think that's going to be this driver of what makes you different to perhaps your peers.
Yeah, I think that's another excellent point. And Dave?
From my perspective, be good at dealing with people, because the machines will be spitting out the answers. They don't need you for that. What you need to do is to know how to solve the client's problems, work out what they are, and be the intermediate between the system and the person.
Building on that, and as we discussed, as Angus and David pointed out, that there is an implied competency of technology. So as you enter into this new phase of legal practice, openly accepting that change is an inevitability and a necessity is a really great attitude to have, so then you can approach and apply your problem-solving skills to help your clients.
That's a really good point.
Yeah, and quickly, I'd just say, similar to what the others have mentioned, it's really about the client and solving their challenges. So I think if your mindset is really, how do I help others, how do I help my client, I think everything else will follow and fit in.
I think these are all insightful words to end a very interesting and comprehensive panel discussion. In my view, to answer the question that I posed, because I think that's a good way to throw myself into the mix as well, is retaining passion for legal practice and passion for the service of the public generally as legal practitioners, whether that be in the mode of operating within a law practice, outside of a law practice, in legal support, or anywhere else that touches in the many paths that can follow from a law degree. I'd like to thank all the panellists here. That was an excellent conversation, and thank you very much for spending your afternoon with us here today. Thank you.
Thank you.
Thank you.